Thank you. Good afternoon. In the past, it seems a long time ago now, the law was known to and understood by the general community. It was in substance customary law, developed over the ages and aptly called the common law. Now, it isn't because more people can read and write that the legislators keep on attempting to reduce that old law into writing and to legislate for far more law. Now, it may be accepted that populations have increased and the complexities of business affairs has expanded, but there are some, and I'm one, who strongly believe that legislators legislate too much and in language insufficiently informed by a broad education. Another criticism is that legislators rarely pause to consider that each new law will always or almost always require a new or enlarged bureaucracy with its own insiders' acronym-laden language to oversee compliance with it. There are three respects in which an acquaintance with the best writers should be regarded as indispensable to all people involved in the law. The first is that reading the best writers painlessly educates in the simplest and clearest way to write. Secondly, broad reading, including in fiction, tells us facts that we would not otherwise know. And thirdly, in a way, and the most important of all, the best authors give us an insight into human behaviour. Included in the store of knowledge that Western civilization holds is, of course, the Bible, the relevance of which is, if anything, increased rather than reduced by the gradual secularisation of society which has been occurring throughout my lifetime. There was only once, I think, during the 10 years that I sat on the High Court, that biblical allusions were made. These occurred, curiously enough, in a case concerned with damage caused to the cargo of a ship during a tempestuous passage across the Great Australian Bight. The references were made because the Hague Convention, which governed the issues, used the expression perils of the sea, taken directly from the Bible. Some of you may have heard of the famous law case of the snail in the bottle, Donoghue against Stevenson, which determined a new and less uncertain order for the law of negligence, and only incidentally decided that an action could lie against the manufacturer of the soft drink in which the dead snail's corpse floated. In the course of his famous speech, Lord Atkin in the House of Lords used the language of the parable of the Good Samaritan from the New Testament. On the 80th anniversary of that famous case, my former colleague and Chief Justice, the Honourable Murray Gleeson, in a speech which he gave in Brisbane, made the point that, unlike now, in 1932 a judge could quite confidently make a biblical allusion of which practically everyone in British or indeed Western society would be aware and would understand. He pointed out that a judge today would probably need to footnote the reference, as indeed I did in the case about the perils of the sea. We should be willing to accept that a deal of the foundation for the common law, and indeed even some legislation, is to be found in the Christian religion of Western society, despite the secularisation to which I've referred. A secularisation which has tended to substitute what Mark Steyn has called rock star morality for Christian ethics. That there is such a foundation in no way itself impairs freedom of worship or gives rise to a concern that the nation is an intolerant theocracy. The fact that other cultural heritages may in the past have been debased is no reason not to be proud of the best of our Western civilization itself. Even if one were an atheist or a follower of another religion, in speaking or writing in the English language, that person would find much in the Bible, especially the King James Version, to improve clarity and, when required, vividness of expression. Until at least, I would say, about 1960, most judgment writing, indeed most writing of any kind in the English language, owed some debt to the language of the King James Version of the Bible. The idea of a specialised and intense legal education is a relatively modern one. The main prerequisite for a successful career as a barrister used to be a sound education in the humanities. A subsequent, fairly brief and rather perfunctory legal education would then be regarded as sufficient for admission to the ranks of practising barristers. Today, as some of you would be aware, a conventional law degree requires the study of a specific number of legal subjects, including some so-called core subjects. No non-legal subjects are required. I would myself have very much liked to have done an arts degree before I took my law degree. Unfortunately, I had to be self-supporting as quickly as I could, so I couldn't do that. Even so, a full-year course in English, political science, a foreign language, and one other arts subject had to be taken before a law degree could be awarded. Not much, you might think, and it wasn't much, but it did at least give me an indication of the immensity of what I didn't know. It's almost inconceivable to me that those who now specify what lawyers have to study in order to become lawyers do not include those elements, and in particular the English language, as necessary elements of a law degree. I chose myself philosophy as my optional arts subject, and I think it was a very good choice. The English language is the weapon of the advocate. It can also be a formidable instrument in the hands of a literate judge. When I started at the bar, I had the good fortune to have as my master and mentor an outstanding jury advocate. In a criminal case, he warned, never make a joke or laugh at anything that occurs in the courtroom. Everyone else around you may be laughing, but it's not for you to do so. A criminal court is a very serious place. Another wise piece of advice he gave me was never to try to cap a judge's joke. I tried once and rather regretted it. I was appearing before a judge with a Scottish name and a well-deserved reputation for Scottish financial prudence. I submitted in the presence of a crowded courtroom that my opponent's client should not be heard to deny a representation which he had made and upon which my client had acted to his detriment. The judge scoffed at my submission. What do you say the reputation was? I said that it was a written account which had been sent to my client and was stated to be a final account. The judge combatively responded, "Final account? I often receive second or third accounts which bear the words final." Now, I knew I shouldn't say it. It was one of those moments. I couldn't help myself. I said, "I wouldn't know about that, Your Honour. I pay my account when I receive it." My riposte was very, very much enjoyed by the crowded courtroom. I can't say for sure that's why I lost the case. Now, the judges of the past were undoubtedly very, very literate, and almost all of them had had a classical education. One of the greatest modern such judges was His Lordship Justice McGarry, as he then was. I think a passage, which I'll read you a brief part about, is one of the best passages which has been written in the law in the last 100 years. He started, on June the 20th, 1909, Errol Flynn was born in Hobart, Tasmania. And on October 14, 1959, he died in Vancouver. When he was 17, he was expelled from school in Sydney, and in the next 33 years, he lived a life which was full, lusty, restless and colourful. In his career, in his 3 marriages, in his friendships, in his quarrels and in bed with the many women he took there, he lived with zest and irregularity. The lives of film stars are not cast in the ordinary mould, and in some respects Errol Flynn's was more stellar than most. When he died, he posed the only question I have to decide: where was he domiciled at the date of his death? It seems to me that those sentences are perfectly balanced. The issue is elegantly defined. The language is simple. Its rhythm reads like a piece of blank verse. Later in his judgment, the judge said that he'd been assisted by a memoir on which Errol Flynn had collaborated with a professional writer. He said of that, "I am not covertly suggesting that what was said in the book is untrue, but truth is many-sided, and a wrong impression is perhaps more often conveyed by what is omitted than by what is said." An apt description sometimes of the popular press. Nor is it an unknown that in the telling, a story intended to entertain should grow and be refined. But just as a man in lapidary inscriptions is not upon oath, so may autobiographies, even though verified by the oath of a collaborator, fail accurately to convey the whole truth and nothing but the truth. The debt owed by the law to Western civilisation and its literature is by no means one-sided. The law, its participants, those ensnared in its processes, and the drama of its proceedings have always provided rich fodder for authors of both fiction and drama. Although Portia's famous plea for mercy in The Merchant of Venice was not made to a British court, it might as well have been, because it bears all the eloquent trappings of a final impassioned plea for a convicted person by an accomplished advocate. A great deal of the best literature of the 19th century is concerned with, and the plot often turns upon a legal outcome. Galsworthy, himself a lawyer, made Soames Forsyte, a man with a preoccupation with property and legal forms, one of the most memorable characters of his saga. In Dickens, talk of estate's tale, lawsuits, legacies, trusts, marriages, settlements, will constructions, wardships, and the legal byways of Doctors' Commons are discussed. In David Copperfield, the villain Uriah Heep is a solicitor's clerk. The recurrent detention of Micawber in the Marshalsea, the debtors' prison, teaches us something of the way in which the bankruptcy law then operated. Authors of fiction haven't always taken a favourable view of lawyers and the legal system. Dickens certainly didn't. He wrote a wonderful chapter about Mr. Pickwick's lawsuit when he defended a claim against him for breach of promise of marriage, a cause of action which is now no longer available. Partly, I think, as a product of feminism and the view that, dare I suggest it, it would be terrible if a man could sue a woman if she failed to honour a promise to marry. But in his chapter, dealing with their case, he wrote this. He said, if Mrs. Bardwell were right, she was the plaintiff of course, it was perfectly clear that Mr. Pickwick was wrong. And if they thought the evidence of Mrs. Cluppins worthy of credence, they would believe it. And if they didn't, why they wouldn't. If they were satisfied that a breach of promise had been committed, they would fine for the plaintiff with such damages as they thought proper. The jury then retired to their private room to talk the matter over, and the judge retired to his private room to refresh himself with a mutton chop and a glass of sherry. The debt owed by the law, or debt owed to the law by authors, is not owed only by Anglophone authors. Balzac, for instance, has many characters who are in the law or closely connected with it. The bad light in which lawyers have sometimes been cast isn't confined to novelists. Playwrights and lyricists have often noticed them adversely. Most of you will have heard the words of Sir William Gilbert in the comic opera Trial by Jury. You might remember that the song there is about a young barrister who had tired of dinners of bread and water and contrived in consequence to fall in love with a rich attorney's elderly, ugly daughter. The song continued, "You'll soon get used to her looks," said he, "and a very nice girl you will find her. She may very well pass for 43 in the dusk with a light behind her." A great strength, I think, of Western civilisation, both its literature, its ethics, and even to some extent its law, is its capacity for humour and self-mockery. But I should abstain from any further humour. This is a very serious institute. I spoke earlier of the need for a liberal education. Reading beyond the law should not, however, be confined to prospective lawyers. Practising lawyers and judges would do well to continue to read fiction and to attend the theatre. This is a theme which is developed by Martha Nussbaum, the distinguished American philosopher, in Poetic Justice, the Literary Imagination and Public Life. It is her opinion, which I fully endorse respectfully, that judges do need to read extensively, the better to understand human affairs and human frailties, to achieve, I think the current fashionable expression is, emotional intelligence. Nearly all the writers whose work has lasted have to a large extent been guided by the moral purpose of Western civilisation, of promoting the triumph of good over evil. The ends of morality can sometimes be achieved by a work in which evil does prevail. This is so because it brings home the enormity of the result and the need for corrective measures to cure it. The most skillful of writers have been able to achieve their purposes without detracting from the interest and entertainment of their fictional works. I returned, as any basically educated person in the English language is bound to do, to Dickens. His writing made a major contribution to reforms of child labour law. An American author, Upton Sinclair, in his powerful novel The Jungle, wrote so compellingly about the meatpacking business in Chicago that President Theodore Roosevelt was able to procure changes to the oppressive labour laws of the day and the deficient food hygiene laws. Sinclair, who lived to age 90 and wrote about 90 books, was also a journalist, a polemicist, essayist, critic, political pamphleteer, and ultimately a failed political candidate. His World's End fiction series, despite some improbabilities of its plotline, in 14 volumes, gives one man's comprehensive view of the political history of the 20th century. I read those 14 books when I was a youth, and I think they gave me as good an education as I would have had, or as I would have in a 3-year modern history course in a university today. Winston Churchill, whose every intellectual, ideological fibre was opposed to the socialist ideas of Sinclair, was nonetheless overawed by the force of the jungle, which Sinclair wrote when he was only 28. As Churchill put it, in his own stylish way, the book had agitated the machinery of a state department, and disturbed the old world and the new, and perhaps the consciences of mankind. Churchill empathised with Sinclair's poor migrant workers, whose way of life would otherwise have been unimaginably remote from Churchill's, which began with his birth at Blenheim Palace. Winston Churchill's almost contemporaneous lengthy two-part review of the jungle can be found in an obscure North American journal, published in 1905. Churchill himself always claimed that he had to and was able to support himself by his journalism and other writing. By reason of his career in politics, it's overlooked sometimes that he was awarded the Nobel Prize for Literature, principally for his magisterial history of the English-speaking people. Even though his distinguished literary contemporary, Evelyn Waugh, described Churchill's prose as sham Augustan, it is fluent and read by many, and his history is a magnificent repository of information about the English-speaking peoples of Western civilization. No contemporary contemplation of the language should overlook the art forms of the electronic media. The electronic media, together with motion pictures, may not have entirely replaced live theatre, but they have made a dent in it. They are not in this country, however, the only contributor to that. Government subsidisation of state theatre companies, an institutional name for what have become institutional bodies, another form of state meddling, has, I think, played its part. Let me take as an example my own home city. As late as the 1950s, by when motion pictures were much patronised and enjoyed, live theatres accommodating audiences of 1,500 or so people continued to flourish. They were not subsidised. J.C. Williamson, a long-standing commercial impresario company, often imported for the leading roles famous overseas actors, generally from the West End of London, to star in what used to be described as well-made plays. The frequent presence of these stars and their drawing power ensured sell-out houses. Their presence made it certain that there would also be work for supporting Australian actors, stagehands, designers, lighters and costumiers. The productions served too as an inspiration and lesson to Australian amateur and semi-professional companies who learnt a great deal from them. Today, professional theatre is dominated, and often aggressively so, by the state theatre companies who resent commercial competition and whose objective so often seems to be more didactic than entertaining. Political correctness and self-indulgence and dwelling upon personal preoccupations tend to reign. It is not as if state theatre has produced very many successful or enduring playwrights. Indeed, the only way in which culture and good culture is produced is by talent, dedication, creativity and persistence. I wonder whether taxpayer subsidisation of theatre, if it is to occur, might be better done by helping the many amateur and semi-professional drama societies who would require very little to do a great deal better. Nowadays, a kind of cultural xenophobia is abroad. You would find it almost impossible to see in Australia a play written by any writer from the United Kingdom before 1960, except perhaps for the odd play by Noel Coward. This seems to stem partly from a reaction against what used to be called, some would say quaintly, the mother country and some of its marvellous institutions. It's not now easy to import a star even, to breathe life into an otherwise Australian production. You may be interested to know that Regulation 2.72D6, made under the Migration Act 1958, provides that a temporary work entertainment visa will only be issued for a visiting entertainer if the minister is satisfied, among other things, that the producer has consulted with relevant Australian unions to the employment or engagement of the proposed imported star. In practice, the consultation tends to have been treated as a right of veto, as readily exercised as the Russian veto on the Security Council during the Cold War. In those circumstances, lacking as it would the drawing power of someone like, for example, Errol Flynn, the production doesn't go ahead, and there is no employment benefit to Australians, let alone net employment benefit, for which paragraph B of the same regulation refers. Neither Western civilization nor the institutions and laws of it are flawless, but Western civilization and our legal system do have much to be proud of. George Orwell, a master himself of clarity and perspicacity, has written of the rigid, stern English judge who, notwithstanding his upbringing and privileged position in society, is nonetheless unwaveringly and utterly incorruptible. Our democratic institutions, of which our legal system is a notable part, again, with all of its flaws, as Winston Churchill put it, a manifestation of the least worst form of government tried. Speaking as I was a few minutes ago of the electronic media, and as I now am of government, I am reminded of one outstanding exception to the generally banal and superficial literature of television. The exception is, of course, Yes Minister, and its successor, Yes Prime Minister. Incidentally, while I was preparing this paper, I happened to catch a rerun of the episode in which Hacker is Minister for the Arts, and Sir Humphrey is trying to persuade him to increase the subsidisation of it. You might recall, if you've seen that Sir Humphrey says, well, it's just a way in which the government gives back to the middle classes some of the taxes that the government's taken from them. The characters and dialogue are so good that there's practically no need for sets. It's now a requirement of any practitioner of any profession that the practitioner undertake continuing education. My suggestion for the improvement of government is that there be a compulsory political education program that requires every politician promoted to a ministry to watch all of the Yes Minister and Yes Prime Minister series and sit and pass an examination on them afterwards. My acquaintance with bureaucracies and their obfuscation of their nominal masters, the ministers, suggests to me that the series is about 90% accurate. Finally, and you will forgive me, I hope, for finishing on a humorous note, I'll say something about two great writers of the last century, each equally repugnant to the other. George Bernard Shaw wrote to Winston Churchill, inviting him to attend a performance of Shaw's new play and to nominate a night to attend with a friend if he had one. Churchill replied, "I've chosen the second night, if there is one." Thank you.